We reported on Friday on Groupon's chairman and biggest shareholder, Eric Lefkofsky, and some of his not-so-successful past ventures. That, combined with Groupon's lack of profits, has led to an intense debate about whether the company will be a success. Now, the SEC imposes a so-called quiet period on companies in the days leading up to an IPO. In other words, no fair pumping up the stock. But wait till you hear what Lefkofsky told our own Corey Johnson on Friday. Now, Lefkofsky, Corey, I understand, called you. What did he have to say, and how unusual was it?
Yeah, just to be clear, the context. So we were going to do this story on Groupon on Friday. We reached out to Lefkofsky. While we were on the air, he called my voicemail. So as soon as I got off the air, I called him back, and we had this conversation. And he was talking about his successes as a businessman. He hadn't seen our story yet and wanted to know what I thought his reaction would be. I did not hazard a guess. And then he talked about some of the other companies that he's taken public, specifically Inner Workings and Echo Global Logistics. And here's what he had to say, and I'm going to read from my notes to make sure I get it exactly right. He said, "I'm going to be in technology for a long time," he told me. And he went on to say, "I'm going to start a lot of companies. These are not sham companies. These are great businesses. Inner Workings is profitable. Echo is profitable. Groupon is going to be wildly profitable." I was shocked that he had that much to say about this company that is in registration right now. And I think that's a topic that we'll continue to look into as people look at this IPO filing. Emily?
Interesting. All right, let's bring in a securities lawyer, Noah Hagey, managing partner of the law firm BraunHagey. Noah, welcome to Bloomberg West, first of all.
Thank you, Emily.
Hearing that the chairman of Groupon said this the day after the IPO, filing for the IPO, how does that strike you? Is that a serious violation?
Well, it certainly raises some questions, and I think that one may suspect that Mr. Lefkofsky is trying to pull a page out of Larry Page's playbook by making a number of statements in connection with his company's public offering. The issues connected to securities and securities prospective disclosure when you're having an offering traditionally had been, and this had been the case for half a century, that there is a simple blackout. You don't make any public statements other than what's in your registration filings, and the purpose of this was to ensure that investors and folks in the market would have an opportunity to make a deliberative assessment, one that was not colored by public pronouncements that may have fluff or puffery connected to it. In 2005, in reaction to some SEC action that was taking place in connection with Google and some other companies in connection with their public offerings, there was an effort to relax some of these restrictions. And those restrictions, although relaxed in dealing with new media issues, still present a problem for folks like Mr. Lefkofsky, who is simply prompting folks to take an interest in his company during a registration filing and making statements that may potentially conflict with what's actually in the registration. And so in cases like this, it's difficult sometimes to handicap what the Commission, the Securities and Exchange Commission, may do. But what we see is that the SEC gets interested when there is a very bold pronouncement which conflicts potentially with what is in a registration statement. And so, for example, in Groupon's case, their registration statement is very specific that they do not see themselves as being net profitable in the near future or even in the medium-term future. So that obviously is going to be a problem when you compare it to Mr. Lefkofsky's public statement that the company, in fact, is going to be wildly profitable. Then you have the second issue that there is going to be a need for Groupon to actually amend its public filings to disclose Mr. Lefkofsky's statement. And then third, of course, the SEC is going to be interested. Yes.
No, let me jump in. I'm sorry to interrupt. But let me jump in. So are you saying they're going to have to come out with another filing, that they're going to have to somehow update their filing to reflect the fact that the prospectus says they might not be profitable, but the chairman's out there telling me that they're going to be wildly profitable?
Yes, the rule of thumb is that within 4 days of making the public statement to you, they would need to amend their filing and actually disclose it to the SEC and potentially provide additional information that either corroborates what Mr. Lefkofsky has said or discounts what he has said.
Now, what could possibly be wrong with that, Noah? I'm sorry.
Corey.
What could possibly be wrong with a company saying that they're going to be profitable? The chairman of a company saying that they're going to be profitable. Why would the SEC have a problem with that? Isn't that the assumption if they're bringing a business public?
It may be the assumption in certain parts, but of course, that's the reason why we have registration filings with detailed financials, where you have somebody with insider knowledge and status making predictions about how the company is going to perform, which conflicts or potentially conflicts with what's in a registration statement. I think that draws attention. And
you made the suggestion that Groupon might have to make a recessionary offering. Can you explain why you think that and what that is? Sure. So there are a couple of tools that are in the SEC's tool bag in this kind of a case. One is they can certainly delay the offering to allow there to be a cooling off period. They can ask for there to be additional disclosure, which is something I think inevitably would happen if I were advising Groupon. Certainly they would preemptively want to do that. And then third, they can certainly say that potential investors who may have relied on Mr. Lefkofsky's statement should have a right to rescind their purchase of shares should they be dissatisfied sometime in the future. So the investors can sell their shares back to the company at the original price? Potentially. If they feel that they were potentially, if that's part of the SEC order, yes. All right. Thank you so much for your perspective on that. Great to hear from a securities lawyer on these issues.